and welcome to this special show on ET Now. We are calling this the Data Debate, just a day after the TRAI issued recommendations on privacy, security and ownership of data. Now, this is being hailed as very good recommendations from a user perspective, and who better to talk to us on this than RS Sharma, the chairman of the telecom regulator TRAI, who joins us on this special show on ET Now. Mr. Sharma, thank you so much for joining us on ET Now. Nandan Nilekani has often said that India is going to be a data-rich country before it becomes economically rich. And you also started your, paper yesterday talking about the number of internet users in India. It's close to 462 million, out of which you say 282 million spend at least 7 hours every day. So, how critical is this subject for you going forward? I mean, going by the recommendations, you've really kept users at the heart of this issue. But how critical is this going to be for India going forward?
You see, as you mentioned yourself, the number of internet users in India is crossed 450 million. Also, the fact that today India is consuming more data than the United States of America and China put together. The per capita data consumption is one of the largest in the world, about 6 GB per capita per day. So this is not per day, per month. Now this is a situation where we indeed have already become data rich, and we may not be a rich country in that sense. But it is important that the adequate protections are provided for consumers in the telecom sector regarding the ownership, security and privacy. Now, our entire recommendation which was issued yesterday is predicated on the fact that it is the user who generates the data. He should have the primary control of his or her own data. And the rest of the players in the ecosystem are essentially custodians of that data. So that's where we begin the entire kind of set of recommendations.
Right. Mr. Sharma, while the verdict is unanimous that these are very progressive points and recommendations coming from the TRAI with respect to ownership of data, with respect to explicit consent, the fact that, the people processing the data are not the owners, it's in fact the users who are the owners. But one thing that everybody is asking about is the timing of these recommendations. This comes just a few weeks or days before the Srikrishna Committee will put its own framework before the government. Did you sense that there is perhaps a vacuum as of now when it comes to regulation, which is why you went ahead and gave out these recommendations? I mean, is this a sense that perhaps India's data protection law is going to take a long time because once the framework is submitted, it then has to go through a standing committee of the parliament, and then we do not know when it will finally become law. So did you sense a vacuum, which is why the TRAI has now stepped in with its own set of recommendations as far as telecom networks are concerned, the digital ecosystem is concerned?
Let me divide the answer in two parts. One is that just to give you a perspective, we started this consultation on 9th of August last year, 2017. Justice Srikrishna Committee was formed on 31st or 30th of July last year. So more or less they happened at the same time. So during the process of this consultation, we got huge amount of inputs, and I have said earlier that whatever comes out of it, whatever recommendations we make, they will go as an input to Justice Srikrishna Committee. Secondly, we have also, if you see the whole recommendation, we have divided the entire space in two parts. One is which is specific to telecom sector. Another is which is a general issue of data protection. And on those general issue, because Justice Srikrishna Committee is expected to give their recommendation, we have eschewed from giving any recommendations to the government. We have actually said that these are the general issues. For example, the rights and responsibilities of the controllers, data sandboxing, using data to create businesses, cross-border flow of data. These are some of the issues which we have not really, while we have analyzed the responses and done our and analyzed the inputs, we have not given any recommendation saying that this Justice Srikrishna Committee will give its recommendation. We have limited ourselves only to the telecom space. Now, the second part is, why did we do it for the telecom space? As I said in the beginning, the data play has become extremely important in our country, and it's important that we put a framework specifically because the TRAI has the responsibility of protecting consumers' interest, and we feel that protecting the consumers' data, ensuring their safety and security is certainly one of the important things. There are already provisions in the telecom service providers licenses. There are provisions in the IT Act. There are various other provisions which actually cast the responsibility of security and secrecy of the telecom users' data. For example, the telecom service providers cannot divulge the telecom users' data to third parties, etc., etc. However, what has happened is that there are multiple players which have come during the last few years. For example, you have devices, you have smartphones, and their number is increasing at the rate of 25 million per quarter in our country. And these smart devices, the operating systems, the browsers, the applications, they all actually get the data from the consumers, and they actually store the data on their clouds or their systems, and they analyze. So therefore, it is necessary that we have some rules for them. And the fundamental rule and fundamental premise, as I said, is that the users must have some control on that data. So if they use the data, they must take the consent of the users. They must inform the user, and that's precisely what broadly is the sort of summary of the recommendations, if I may use that term.
Right. Just a quick follow-up to that, sir. Were these recommendations also given to the Justice Srikrishna Committee, because they've invited recommendations from a cross-section of society since August last year. In fact, it was almost going to be submitted to the government, but there has been a delay. Did the TRAI also submit its recommendations at that stage?
No, so what we are going to do is we are going to send these recommendations along with all the inputs which have been received to the Justice Srikrishna Committee, and we hope it will serve as an input, as an important input to the committee.
Right. And so what happens when the law comes, based on the Srikrishna Committee report? Should we assume that it will take into account, the concerns raised by the TRAI, by the RBI, by the UIDAI, perhaps when it comes to, issues around Aadhaar? Should we assume that this one law will sort of subsume the concerns of the various regulators?
Obviously, if there is a law which is enacted by the parliament of this country, that law will supersede everything else. So that's absolutely, that's what we expect, that law will take care of multiple issues. Specifically, we have said that till the law comes into place, there are certain responsibilities which should be cast upon the players in the digital ecosystem of the telecom space. That's what we have recommended.
Right. So the other part that I want to come to is, a very important suggestion that you have given, where you say that, the existing laws that cover telcos should also cover players such as browsers and operating systems and apps, and other players who process a large amount of data using telecom networks. Some would argue that, these apps and other players are already governed by the IT Act. Wouldn't this inhibit innovation in some way? What would you say to them? Do you think the same rules that a telco follows must also apply to the ecosystem that's riding on the telcos?
No, we are saying IT Act certainly prescribes, certain penalties for data breach. It defines what is personal data and stuff like that. In addition, the telecom service providers licenses also cast upon them certain responsibilities. What we are saying that is that till a general data protection law comes into force in this country, we in the meanwhile cannot just allow completely unregulated use of data by the entities who are actually consuming a lot of data of the telecom subscribers. And therefore, we have said that a similar kind of dispensation, they should also be brought and mandated to follow certain basic principles. And these principles are, we have enunciated in our recommendations, which is essentially the notice, consent, security, safety, etc.
Right. So one important point that I saw in the document yesterday, you've said all entities in the digital ecosystem which control or process the data should be restrained from using metadata to identify the individual users. Can you tell us how this can be implemented? Because digital ecosystem is a very wide space, it will include a multitude of players. If this were to be taken as a regulation or as a law, how will one go about it, sir?
No, you see, we have given this principle that, these are the best practices for ensuring the citizens' privacy and the protection of their data. As you must have noticed, one of the things which we have not prescribed our detailed recommendation is the audit of this entire exercise. And we feel that the data protection law, when it comes, will also, take care of the how do you audit this trail, the digital trail of how the data was used, how the data was anonymized, how the data was de-anonymized, and etc. etc. We have given this principle that you should do this and you should do this. How the principle will be enforced is something we feel that this is a general principle of entire data protection.
The other point that I wanted to come to was, you yourself said that there were certain parts that you did not address because this would be left to the committee to address it during the course of making this law. You mentioned, data localization, cross-border data flow. One more aspect that people are talking about is, where does lawful interception come in? Where do exceptions to privacy come in? There is one part in your document where you said that, this will apply to private bodies as well as the government. But can you give us more details here? Because just a few days back, the Supreme Court pulled up the government because they wanted to screen WhatsApp messages. They said that, that this will send out a message that we are perhaps creating a surveillance state. So should there have been more clarity there on where the government's limits end, or where there can be exceptions with respect to law and order or national security?
No, look, we have made two parts. One is, we have said that let's say right to be forgotten is what we have mentioned in our recommendation. What we have said is that all these rights obviously will be subjected to the legal framework. So, for example, licensing frameworks prescribed the lawful interception methods, right? And therefore, everything has got to be subjected to those methods. So that's one part. And secondly, exception to these principles of privacy, those principles are again we have not dealt with. Actually, if you remember, there are about six topics on which we have very clearly stated that this is a part of a general law, or it's a general issue, not really limited to telecom space, and therefore we have not given our recommendations. And one of the this is actually exceptions to this situation.
Right. And you've also said that, to ensure privacy of users, the national policy for encryption of personal data should be notified by the government at the earliest. Now, the government actually withdrew the draft national policy on encryption the last time around. So, what can be expected this time around? Can we expect a better draft? What can we expect on that front?
See, when we went into this question as to, one of the important things is that if you want privacy or if you want data security, encryption plays an extremely important role. And when we looked at the landscape of encryption in this country, we found that there are different rules for different, sort of sectors. For example, in telecom, the maximum encryption is proposed to be of 40 bits. Similarly, the financial sector has notified certain level of encryption. UIDAI, for example, has the highest level of encryption, where it is 2048 bit. So what we are saying is that probably there is a need to have a general policy on encryption, and we are not saying that we should apply the same encryption standards. Probably the encryption standard will be proportional to the security which you want to achieve, and each sector probably can have different encryption standards, which is not, we are not saying that. Uniformity is not really, may not be required, but I think we need to have a policy framework on this issue, and this is precisely what we have recommended.
You've said the terms and conditions given by apps, given by devices at the time of sale, it should be very simple, it should not be complicated, it should also be multilingual, there should also be an option to delete pre-installed applications. What was the thinking here, sir? I mean, did you refer to global standards such as the GDPR, or do you feel that people are perhaps collecting too much data at this point and there's no accountability for what actually happens to that data after it's collected? Just take us through the thinking behind these two facets.
Absolutely, you are right that people and applications are collecting more data than what is needed by them. And I'll give you an example which is very interesting. You have this application which actually makes your telephone, smartphone as a torch, right? There's something called light, torch application. Now this torch application requires you to provide your contact list to them. Isn't it ridiculous? Why should a torch application, which actually just activates a torch facility in the telephone, a smartphone, would require your contact list? Similarly, many times I understand that if your application for basic functioning requires certain data, then it's okay. For example, if there is a navigation application and it says that I want to require your navigation data as to where you are going so as to give you feedback, it's understandable. But what is not understandable is that you require some access to some data, you require access to camera, for example. Why should a torch require access to a camera? We don't understand. So similarly, we have, I feel that many applications are actually collecting huge amount of data and one is not aware as to what they are doing. So essentially we are saying two things. One, there should be some nexus between what you require to access in terms of data and what you are performing, what your functions are. That's one part. And second part is when you do an agreement, when you ask people to sign on the agreement and you produce a 200-page, 300-page document, not even lawyers will be able to really figure out as to what is written there. So this kind of thing is absolutely unacceptable. You should provide these agreements which are readily understandable by a common man in simple English, maybe multilingual. So therefore, both these things are important because the basic principles, there is one principle called privacy by design, and I am happy to say, and let me talk about Aadhaar at this moment, that in Aadhaar we have meticulously followed privacy by design principle. And one of the principles of privacy by design is that you should collect minimal data. You should not collect more data than what is required for your basic purpose for which you are doing the work. So for example, for Aadhaar enrollment, we just collect four set of data: your name, your gender, your date of birth, your communication address, nothing more, nothing less. Similarly, every application must collect as much data as is really required. So data minimization should be one of the basic principles of privacy by design. Similarly, other principles of privacy by design is notice, consent, etc., etc. that we have dealt with. Another important part which I want to share with you is that we have, in one of our recommendations, we have said that users must be empowered to use their data. Not only they should have access to, but they should actually be able to have control on that data. So for example, Reserve Bank of India has notified in 2016 a master circular where they have created what is called data aggregators or data fiduciaries, which actually help the residents to get their data ported from one platform, one bank or other things to other institutions to whom they want to share it with for getting some loans or getting some credits or improving their credit history. So therefore, we should create a similar framework in telecom space also, where telecom users should be able to use their data for their own benefit. So this is another recommendation which we have given, and most of the people have missed this out.
No, sir, I did see that part where, you drew parallels with the RBI, but it brings me to my next question. You mentioned, privacy by design, minimum data collection. Any reason why you left out Aadhaar in that 77-page document? Or, are questions around Aadhaar supposed to be addressed by the UIDAI and it's not something that TRAI will get into, despite the fact that this has become the default authentication, means of authentication for many telcos. In fact, it perhaps led to Jio's surge when it comes to user number. So any reason why this did not have anything on the Aadhaar part?
No, we are discussing telecom space. We are not telecom sector. We are not discussing identity or Aadhaar. I just gave you an example of data minimization. I gave the example of privacy by design. In that context, I use Aadhaar's example. Aadhaar need not be discussed here because Aadhaar is not a part of the telecom sector, isn't it?
Right. Mr. Sharma, the larger question that this document has raised, or these recommendations have raised, is, what are the limits of TRAI's governance? Because when you say digital ecosystem, I mean, it's not just the telcos or the telecom providers. This is going to include the app ecosystem. It's going to include operating systems, browsers, device makers. So what is the ambit of regulation going to be as far as the TRAI is concerned?
No, let's understand very clearly that TRAI has never recommended that you enable or you ensure that all these other players in the digital ecosystem should start getting regulated by TRAI. That's none of the recommendation which we have made, nor we intend to. What we have said is, see, one of the preambles, if you read the preamble of TRAI Act, it says protection of the telecom consumers. So it's our duty and responsibility to protect the interest of the telecom consumers, and certainly the data security of their data, privacy of their data is certainly the responsibility of TRAI, and we have basically given recommendation in this regard that what needs to be done. We are not saying that we need to do it or we should be authorized to do it. That's not the way we have structured. We are basically giving recommendation as to what needs to be done in this changed landscape where India, as you initially said, that India is data rich before we become really rich. So in that sense, I think it is a timely recommendation, and we have been very balanced in our approach to really say what needs to be done at this moment.
Right. Final set of questions, Mr. Sharma. Now that you have sort of released these recommendations, what's going to be the next step? Has sort of the DOT said what they plan to do with this? And DOT Secretary Aruna Sundarajan is in fact part of the Srikrishna Committee panel. So what's going to be the next step here? Has the DOT responded to what they plan to do with these recommendations till the time we have a data protection law in place? Because clearly there is a vacuum as of now, even as India is processing so much of data every second, and we have so many connected devices. What's going to happen, sir, in the next few steps?
I really cannot say anything on that. Our TRAI Act says that TRAI can provide suo motu recommendations, or it should provide recommendations on the subject referred to it by the government. In this particular case, we have provided suo motu recommendation on this issue of data ownership, security and privacy of the data in the telecom space. So thereafter we have given the recommendation to the government, and thereafter it is for the government to take appropriate sort of decision on this issue.
Right. On that note, Mr. Sharma, thank you so much for talking to ET Now and, patiently taking all our questions. The formal data protection framework is still a few weeks away, but clearly the TRAI has set a precedent that the user needs to be at the heart of this, irrespective of whether it comes to ownership of data, security or privacy. Thank you so much, Mr. Sharma, for this special interview.
Thank you very much.